joining. So hopefully we'll have some time maybe at the end for that little discussion. I think this is a very interesting issue, very complicated one, but also I think most importantly it's an extremely important issue and one that we're going to, folks like us are going to have to find an answer to. And it's essentially the topic of my presentation is using litigation to combat climate change. And you know, in particular, I'm going to focus on the difficulties in using litigation to combat climate change. And when I originally agreed to do this, I was going to talk about a case that we had brought a couple of years ago, or several years ago now, against the Department of Defense that we lost on standing grounds. And as I got into it, I thought it might be more instructive just to kind of go over some of the more seminal cases, and perhaps at the end I'll touch briefly on the case that we brought. I don't usually like talking about cases that I lost very much, but as you'll see here, they're very tough to win, and when you get a Reagan appointee who doesn't believe in climate change, you're probably going to get kicked on standing when that's your basis for standing. So anyway, you know, I guess first and foremost, just to start off, you know, and I'll touch on this in a minute, you know, I'm sure most of us are like-minded in this room, and more importantly, I think, you know, scientists now broadly recognize the dangers that the increasing concentrations of greenhouse gas emissions in the atmosphere, and carbon dioxide in particular, and you know, the dangers posed by the increasing concentrations. But despite that, there's not really any comprehensive, you know, legislative. You know, there's some regulatory act, some movement. I won't call it action, movement, which I'll discuss in a minute. But there's no, you know, there's not like there's a climate change, you know, recovery act or something with a nice little citizen supervision in it. You know, so you kind of have to get creative, and anyhow, so we're talking about, you know, what's the objective? We're trying to hold, you know, government, private entities, whomever, accountable for their greenhouse gas emissions and the contribution to climate change and the resulting harms. And of course, what we're talking about here is the combustion of fossil fuels, you know, coal, oil, natural gas for energy, transportation, and industry. And as I mentioned earlier, particularly, I happened to catch this picture at the Progress Energy plant in Asheville. It's quite amazing. It's quite amazing, I know. But first, I just wanted to talk about a couple of really things that are very recent. In fact, I think almost as I was putting this together, as many of you know, I'm sure the Intergovernmental Panel on Climate Change recently came out with its 5th assessment report. Obviously, I'm not going to go into details if y'all have looked at that report, but just very generally, they found warming is unequivocal. They found that humans are the dominant cause of the increase in warming, and they found that to a 95% certainty. They said it was extremely likely that humans are the dominant cause, and I don't know if we have any scientists in here, but I have a feeling if we polled scientists, is the sun going to come up tomorrow, we might get 95%. So I think I think that's very important. I found this little thing which I thought was neat. Hashtag debate is over. And I don't know if y'all can see that very well. It looks like you can. But in '95, the IPCC was 50% certain that humans are the dominant cause of climate change. And y'all notice I don't call it global warming. I don't like that. I call it climate change because I think that's more representative of what it is. Whereas now we're at 95%. So, you know, in roughly 15 years, it's almost doubled. And so, you know, for the naysayers, you know, I guess they have their arguments, but I don't think they have much of a scientific basis to argue that. Another recent development, President Obama announced his climate action plan in June of this year, and the pillar of that was cutting carbon pollution from new power plants. It won't apply to old power plants, but will apply to new ones. And as you may or may not know, I don't know if I was aware of this or not, but there's currently really no limits on CO2 pollution. There is on other greenhouse gases, but not on carbon dioxide. And of course, carbon dioxide is 30% of all greenhouse gas pollution. So obviously, this is a good step. You know, I commend President Obama for this. And just last month, EPA came out with some proposed rules for the, you know, trying to implement President Obama's plan. New power plants would most likely be implementing carbon capture and storage. That's when they capture it, somehow inject it into the ground to where it can't be released again. I saw something recently from a reputable source that was kind of questioning the technology, but it's my understanding that EPA believes it's certainly doable. But that remains to be seen. And yeah, the rules are would result in 40% less CO2 emissions than the best performing plants today. You know, obviously that'll be great. I think obviously the shutdown has hurt any movement forward on these rules. I don't think that EPA rule writers on these stuff will be essential governmental employees, unfortunately. So, but anyway, so you know, there are some good things going on with the science, and you know, to some extent politically to try to do something. But of course, that's not enough in and of itself. So as I talked about climate change, I like to call it global weirding. I don't know if you can look at this, but you know, this is just something I found on the internet, obviously, but just kind of goes through some of the different things, you know, stronger storms, changing rain and snow patterns, less snow and ice, you know, more droughts and wildfires, rising sea levels, warmer oceans, you know, it's all the things. And you know, you don't have to really do anything but turn on the news. And you know, the one thing that I really look at is the stronger storms. You know, some of the tornadoes that have gone across the Midwest the past few years, Sandy, what they call it, Superstorm Sandy last year that went up and just killed the Northeast. And you know, so again, you don't have to do much than just, you know, be a cognizant observer of what's going on in the world to kind of understand this. So, and of course, we've had impacts here in the Southeast. That's a picture of Katrina. I'll be talking about a case here shortly that was brought to on behalf of individuals who were damaged by Katrina. And we'll see, kind of going back to my topic, the problems they had finding any relief in court. So, and then also, I'm sure, I don't know if anybody here is from Nashville. I know some, kind of Kelly is, and some other folks might be, but I'm sure y'all remember if you were there then. I think it was May of 2010, the flooding in Nashville, just unprecedented amounts of rain. And again, that's just a radar image of that. So, going back to kind of the focus of my presentation, you know, really there's a huge standing dilemma right now when it comes to using litigation. And we got that pesky Article 3. We all know you gotta meet Article 3, Section 2 standard. So on the one hand, what we have is actions brought by states in their sovereign capacity to protect their citizenry. Excuse me. And I'll talk about Massey EPA. I'm sure all of y'all are somewhat familiar with that case. But you know, the Latin term for this is when states bring actions like this is parens patriae. If we have any Latin scholars in here who want to correct me, go ahead. And you know, on the other hand, we have actions brought by private individuals. And you know, I was thinking, I was like, well, I've got this nice little Latin term here, so I need one to describe actions brought by private parties. So I Googled Latin for shit out of luck, and I came up with this. You know, this might be very loose. I don't know. Are we taping this? Alba fortunae stercor. Again, Latin scholar. I don't know. Very loose, but it popped up. And then there's also some other barriers I want to discuss. In particular, kind of building on, I don't know how many of y'all got to see Lou's presentation this morning, which was great, but Clean Air Act preemption of common law nuisance suits after Massey EPA, which is it's something that's potentially a big problem. But we'll get to that. And yeah, I don't know. I think that guy's got standing. What do y'all think? So it's kind of a sad picture, but so again, talking about the standing dilemma. You know, Article 3, Section 2. You know, the court's limited by the Constitution to actual cases or controversies And if you don't have that, you're not going to get into the courthouse door. Of course, we've also got, constitutional standing. I'm sure nobody in here has ever cited Lujan in a brief for standing. And of course, we all know the three elements: injury in fact, sorry about that. Well, I don't need to. Causation, traceability, and redressability. And so first, when we're talking about climate change, what we have here is we have this problem of a global magnitude. And so that's what private litigants are running into when they're trying to go into court to seek redress for damages that they're alleging are caused by climate change. So, in terms of injury in fact, how is the harm of global magnitude sufficiently particularized to an individual case in order to meet that element of the standing inquiry? And then, of course, the real problem, and as we'll see, comes in on causation or traceability. And that's how do you prove that a particular polluter's emissions contributed to your particular injury. There's so many different emitters of greenhouse gases out there. What do? Do you sue them all? Do you sue a certain percentage of them? And we'll see that unfortunately there's been some smart lawyering and it hadn't worked. And then, of course, closely tied with traceability traceability is redressability, and that's will the relief requested provide redress for the injury alleged. So again, as we'll get into, this is probably more of a summary slide that should have gone later, but states, when they're suing in their sovereign capacity, parens patriae, Mass v. EPA, and Connecticut versus the American Electric Power case would seem to suggest, although it's not entirely clear, it's muddy, but would seem to suggest that states have standing when they're bringing an action based on climate change in that regard. And then for private parties, that's the out of Fortune Stair Corps. And the two cases I want to focus on in particular are the Village of Kivalina v. ExxonMobil, and then also the Comer v. Murphy Oil, which is the Katrina case. So, Mass v.
Back just for 1 minute so I can get the sites.
Oh, sure. I'm sorry.
Are your slides on the?
They should, yeah, they should be, but I don't mind going. Some of them might have changed. I don't mind going back.
Thank you.
Yeah. Anybody have any questions at this point? I mean, I don't want this to be me sitting up here talking. I'd love if anybody has anything to add, any point or anything, please do. So Mass v. EPA, we all know a great case for environmental lawyers to a large extent. It's the first time the Supreme Court had really addressed the issue of injuries allegedly caused by global warming in the standing context. And here it was Massachusetts, alleging damage to their coastline due to rising sea levels. And so it was the Mass and other plaintiffs were seeking, basically they petitioned EPA to do a rulemaking to regulate greenhouse gas emissions from motor vehicles under the Clean Air Act. EPA said, oh, we can't do that. So Massachusetts, of course, appealed that decision, and it ultimately got to the Supreme Court. And in the Supreme Court, when talking about standing in particular, the court emphasized, quote unquote, the special position and interest of Massachusetts. Again, getting back to that parens patriae issue. And this is a quote which you see now in almost any case where standing is based on climate change or the impacts of climate change. The Supreme Court held in Mass v. EPA is of considerable relevance that the party seeking review is a sovereign state and not a private individual. So, there's, as I started kind of, getting beyond just the case law and reading some of the scholarly works on this, there really is a question. Was it a relaxed standing inquiry? This was a procedural injury, which folks know you do kind of get a relaxed on certain elements of standing when you're doing that. But the court found, again, emphasized the special position, of the sovereign state. But then it still went through the Lujan analysis. and found that Massachusetts had standing. And so, you know, there's still a lot of question out there about exactly what is the proper standing analysis. Does it end with the parents patriae question, or do you still go through Lujan? You know, the Supreme Court had enough votes, so they figured they would just cover it both ways. It's still
enough votes then.
still a
The
question.
composition of the court has changed.
Sure.
A lot.
Sure. So, and again, you know, the court, you know, finding, going back to the parents patriae, Massachusetts had brought that lawsuit in its capacity of a quasi-sovereign, seeking to protect governmental and public interests that concern the state as a whole, namely the rising sea levels on the Massachusetts coast. And so the term you see a lot, the Supreme Court stated that Massachusetts was entitled to special solicitude in the standing analysis. So,
Quasi-sovereign?
yeah, it's quasi-sovereign because the states, and Chuck, Lou, when I first saw that, I was like, eh? But the theory, I guess, is that when the states gave up some of their sovereignty when they were admitted to the Union. And so they're considered quasi-sovereigns, at least in the legal text. I don't understand it fully either, but that's the best understanding I have of it. So again, you know, after Maskey EPA, you know, it's not real. The thing that's really frustrating is as you read these cases, especially when you look at the Supreme Court's analysis of the Lujan elements in Maskey EPA, they're almost exactly the same as they are in the other cases, but the outcome's completely different. You know, I mean, they acknowledge that, you know, EPA, you know, of course, made the endangerment finding after Maskey EPA, and the other actions they've taken. EPA's acknowledged climate change, but you know, in these other cases, especially when they were in the cases where there's private litigants, they won't find standing, although the analysis is just the same. So the next case I want to talk about is American Electric Power v. Connecticut. This was a Second Circuit case originally, but I'm going to focus on the Supreme Court decision. What this case was a public, so this was not a procedural type case like Maskey EPA was. This was a public nuisance action by 8 states, a city, and 3 land trusts against 4 private power companies and TVA seeking abatement of all they wanted was an injunction. Their damages, public nuisance, seeking abatement of these defendants' contributions to global warming. Now, interestingly, the Second Circuit found that all the parties had standing, including the land trusts, which was very interesting. But the Supreme Court put an end to that. Again, these defendants were some of the largest emitters of carbon dioxide in the United States. I don't remember exactly who it was off the top of my head. I don't know if I have it in my notes, but TVA, of course. So again, to distinguish this from EPA, this was a federal common law action, abatement of a public nuisance. It was not a procedural rights type case. So after it came up from the Second Circuit, and if you read this decision, it's very interesting, all the Supreme Court found is that some of the plaintiffs would have, it's in a paragraph, we find some of the plaintiffs, and it's a plurality, because Sotomayor had to recuse herself. She had heard the case on the Second Circuit. So 4 justices found that some of the plaintiffs, not named, would have standing under Maskey EPA, and so it's pretty clear that they were likely finding that the state plaintiffs had standing. And especially when the court again emphasized that it is not held that private parties can maintain an action like this. So anyway, what the Supreme Court does in the American Electric Power case is they find preemption. They rely on Maskey EPA and hold that the Clean Air Act, and there is a distinction between preemption and displacement. I'm not going to get into that because we could have an entire conference on this issue, but basically find that the Clean Air Act and the EPA actions that it authorizes under Maskey EPA displace any federal common law right to seek abatement of carbon dioxide emissions. So those are the 2 Supreme Court decisions. So the next case I want to talk about is the Village of Kivalina v. ExxonMobil Corp. This case was in the Northern District of California, and let's see, it's first here. Okay, so this time, this was again a nuisance action brought by a native, I should say Eskimo village and a city, it's both Kivalina, against utility companies based on greenhouse gas emissions, which were causing erosion of the Arctic sea ice. And I'll show you here how Kivalina is situated. Now, in contrast to the American Electric Power case, they were seeking damages, not just injunctive relief. And going back, their main complaint was that the sea ice protects them from storms. And the fact that the sea ice was being diminished, they were getting more storms, coastal surges, flooding. And essentially, reading the case, in 1953, the village of Kivalina was 54 acres, and it's now 27. And the Army Corps of Engineers had a damage estimate of 100 to 400 billion. And essentially these folks, and I wish I knew, I couldn't find anything on what the current status is, but they were going to have to move, they were going to have to relocate. They couldn't stay there anymore. And you can see here this picture of them trying to put sandbags, or I assume that's what it is, on their coastal area there. But if you see here, it's just this little barrier island up on the northwest coast of Alaska. And so, the sea ice used to protect them from these storms coming in. And as you can see there, it doesn't anymore, and had essentially taken out half of the island, or the city of the village. The lawyers on behalf of the village, as I talked about earlier, were smart. They sued everybody. BP, ExxonMobil, Shell, Chevron, Duke, Southern Company, American Electric Power, there's more, They figured, hey, okay, these cases are going to say, well, you haven't, you can't show that these defendants contribute enough to cause your problems. So, in response to that, they sued everybody. What the Northern District said, they found that the village and the city lacked standing. And this is a little bit backwards, but on the one hand, just comparing it with Mass v. EPA and the American Electric case, they said the village or the city were not entitled to the same special solicitude that are afforded to sovereigns, because in lieu, this goes back to what we were talking about with the quasi-sovereign, they never gave up any of their sovereignty. They're a native tribe. They never gave up any of their sovereignty, and the court went out of its way to point that out.
Even the fact that they give up literally thousands of acres of land to be, that
Right.
wasn't enough to.
No, right, and I'm getting to that.
Oh,
Yeah, we
God,
can-
I'm so angry.
Yeah.
Maybe we could just elaborate on what you just said, that they had not surrendered their sovereignty.
Well, it's like they're a native,
Right.
they're a native tribe, so they're treated just like Native Americans. They don't give up their sovereignty.
Which in Alaskan, native tribes are much more politically powerfully situated
Right.
than the rest of the
Absolutely.
Native American tribes in
Yeah.
the United States.
Absolutely.
So what you're saying is that because they didn't give up
Their sovereignty, as like states did.
like
And
states,
again, as Lou and I were talking about earlier, I don't fully understand that, admittedly, that states are quasi-sovereign because they give up some of their sovereignty when they agreed to be admitted to the union.
So why don't they just give it up?
it seems like if they
I don't,
had-
yeah. No, yeah, I mean,
Doesn't it seem like
that's,
if they were
that's
sovereign,
a slippery slope if I've ever heard
Well,
one.
if
I mean,
you're
the
gonna
more
lose their
sovereign-
land anyway, why not give it up?
Negative.
Yeah.
Because they give up all their treaty rights.
Right.
That is a
Yeah.
really
Yeah.
awful
I'm not
idea.
even sure they
So-
could do that.
Yeah, the more sovereignty you have, the more power you have.
Yes.
So,
Over yourself.
over yourself.
Right.
So.
And so, but in this case, the court goes out of its way to essentially punish them for that.
Right.
Yeah.
So, but before, so essentially, Corinne's patriotic standing is not applicable to native tribes because they didn't surrender any sovereignty, like states did. Hey, again, this is what our court said, not me. Do I agree with it? No.
Yes.
But before the court even got to that, they found that they couldn't establish Article 3 standing.
Okay.
Despite the fact that they had sued, anybody and everybody who was a major contributor to CO2 pollution, they just, the court said you cannot trace your energy to any acts of any of these particular
You're kidding me.
defendants. So it's maddening, it really is. And, you know, that the court noted that the genesis of global warming is attributable to numerous entities which individually and cumulatively created their injuries, and not all of those are before the court, so sorry. So they essentially saying alleging contribution to climate change is not enough. You know, you have to, you know, we have that traceability requirement, and you have to face it, you know. But that's kind of, you know, something that if we have time at the end, I'd like to talk about is how do we change, you know, how do we make that causal connection? It seems almost impossible.
So in other words, they had to sue every federal government in the world in order to satisfy the court?
Essentially, yeah, every government, every emitter of greenhouse gases, and I mean, like I said, you know, it was great and smart, crafty lawyering, I thought, because they did name, you know, all the big folks. But again, that was the case in the American Electric case too.
You want to have 100 oil company lawyers.
Right.
In the room on the other side.
Yeah. I can tell you, I don't deal with a lot of oil companies. One or two.
Well, how many lawyers do we have at this conference? Let's start organizing.
I mean, like I said, this could be the subject. This could be the subject of an entire conference. It really could. This case did go up to the Ninth Circuit. They affirmed the lower court decision, but solely on preemption grounds, in reliance on Mass, the EPA, and the American Electric Power case, finding that the Clean Air Act, again, it wasn't really preemption, it's displacement. I'm not going to get into that distinction. Basically, preemption is a higher bar than displacement, but it's the same effect at the end of the day. And so basically, you know, what we can learn from this case is that federal common law nuisance actions seeking injunctive relief or damages are now preempted by the Clean Air Act. So the question it left open is, okay, what about actions based on state common law as opposed to federal common law? Well, as you can guess, we're going to get a decision on that. This is the Comer v. Murphy Oil case. There's a lot of other defendants. This was a putative class action brought by individuals against oil companies based on the damages they had suffered in Katrina, basically saying, hey, you know, you contributed to climate change. You know, you made this storm so much worse than it would have been otherwise, and therefore you damaged our property. We want damages. And again, these were state. So it's a common lawsuit like Kivalina. It's tort claims, but the distinction is they were state claims. So the question that had been left open in Kivalina, the Southern District of Mississippi had a chance to deal with here. Yeah, I don't know if we wanted to give them that chance, but it was worth a shot. Something else I want to say, I don't remember right now.
Question.
Question.
Yes.
I'm not a lawyer, I'm an engineer, but how can that kind of case be handled with regard to everything else that's going on along the coast? The natural rising of the ocean level is going to, for instance, put Miami Beach underwater in geologically a short time.
Well, I mean, I'm not sure I fully understand your question, but I think you're kind of getting at the point. It's this, you know, there's all these harms that climate change is causing, and being able to trace, you know, the fact that your property got ruined in Katrina, you know, got demolished, was a complete loss, and tying that to any particular or a group of particular polluters, you can't do it. You know, or at least courts are unwilling to do it as we stand here today.
So that would be the general rule, would it not?
What's that?
All of what you just said, all around the United States where damage is occurring as a result of storms or rising water levels, then whatever happens here is going to be a pattern for what happened everywhere else.
Sure. Private citizens are going to have a hard time, right, bringing tort claims or, you know, trying to get damages based on climate change. When the effects of climate change and you know and what that causes and damages you is the basis for your standing, you're gonna have a hard time. You're gonna have a hard time. Yes.
Well, I'm not a scientist, I was pre-med a long time ago, but isn't there argument logically saying that you have to trace the particular molecules of carbon dioxide? Wasn't that absurd?
That's essentially what the court's holding.
Well, could you argue that the legislature never intended an absurd result like that?
I suppose you could, but I mean, the Constitution's, and how the Supreme Court and others have interpreted the standing, the traceability element of standing, you have to be able to do that. So it's not, I don't think it's so much what the legislature intended, it's more about, standing's constitutional.
Causation in fact has been part of the common law
Sure.
since well before I went to law school, which was a long time ago.
Sure. So again, the court again went out of its way, this is the Southern District of Mississippi, to say that, both Mass and American Electric said, specifically said that they were not holding that private parties have standing to assert global warming claims. And once again, as we kind of got ahead of ourselves, but the plaintiffs could not show the causal connection between the defendant's emissions and the specific damages suffered during Katrina's to an attenuated causal chain, which I might read you from the opinion that we had a couple of years ago, which is just hilarious.
Losing can be fun.
Losing's only fun when it's ridiculous. So basically, again, the plaintiffs could not show that the defendant's emissions caused their specific damages by Katrina. So, yes, ma'am.
In a workshop on the Clean Water Act, it seems like you can kind of be more like if it contributes to the pollution.
Yeah. See, that's some stuff I read in some of the literature. Right, like when people, and in some of these cases, actually the lawyers argued, this is really, the standing analysis should be the same thing as it is under the Clean Water Act, and courts won't go there. They won't go there.
So is it because you're being too general with climate change? Could you not?
Well, exactly, because in a Clean Water Act case, generally you got a pipe, you got a stream. And you got somebody saying, "Oh, I don't like that pollutant there." You know where it's coming from. Here, you've got billions or millions of smokestacks.
Right, but even though it contributes to it at a significant level, it's not enough.
Right, whereas you bring up a great point because a lot of people have written articles on that. And these lawyers, I think in Kivalina and Comer, I'd have to look back, kind of argued that the standing inquiry should be more of a contribution's enough.
Could you not?
But the courts won't go there.
Could you not do a climate change suit through a Clean Water Act suit?
How would you?
Yeah.
I'm not an expert. I'm just.
Yeah. I guess
That would be an interesting question because Lake Whatcom in Whatcom County, Bellingham, Washington, which is where we're from, they can show that 13% of the mercury in the lake comes from China.
Comes from
So
the
then
burning of coal in China
Every
specifically.
piece of mercury has its own signature. And so you can show what portion of the mercury in the water comes from the burning of the refineries at Anacortes and at Cherry Point.
But how do you do that with the swamp?
Well, and that type of scientific proof, if you can prove that, that, but again, even if you can show the mercury came from there, I don't see how you would tie that into a Clean Water Act.
Yeah, it's air deposition.
Yeah,
It's not water
yeah.
deposition.
It's a good idea, and like I said, you're thinking like the lawyers in these cases thought, but the courts, I just don't think the courts know how to deal with this yet. It's the problem. I mean, there's still a lot of judges on the bench who probably don't believe in climate change, or at least don't believe in humans' contribution to it. So they're going to find any way they can, to kick these cases.
Do you have to call in an expert witness every time?
Oh yeah.
Oh, yeah. You need
yeah.
that. You need
Oh,
to do it anyway.
And I'll tell you about the case we did, and we used the guy Mike McCracken. I don't know if y'all heard of him, but he's one of the leading climate scientists in the country. He won the day in asking EPA. If you read that case, they even talk about how he predicted Katrina. I mean, the Supreme Court just loved him up and down. So in the case we did, that I'll talk about here in a minute, we basically took his Massey EPA declaration and then tailored it to our case. I mean, Judge, it's not even noted in the decision, you know? I mean, so, yes, sir.
This is probably way off the subject, but when some kind of international treaty that we were a party to put some kind of a floor under this business so that you could handle cases under international law in terms of damages? And it seems like to me that what you're saying is that there's no remedy at all for domestic law in these kinds of cases.
For
So,
private litigants, absolutely, as it stands now, right?
I've got a question. I appreciated what you all said over here about mercury having a signature that's traceable. And one of the things that's happening in western North Carolina is the mercury emissions are raining down onto the lakes such that the fish are being contaminated. And 3 years ago, we had a guy rush to a local hospital and they discovered he had mercury poisoning from eating fish twice a week from Fontana Lake. Why can't we use, based on what y'all are talking about, the mercury signature in, say, Fontana Lake, and then pursue the EPA stuff with regard to contribution?
That's a Clean Water Act.
I mean, excuse me,
Action,
yeah, why
not-
can't, I mean, you're talking
And
about
their action of it.
deposit,
And, yeah,
depositing mercury, it's in the water.
but
And
that's,
How did he get in the water? is the
that's
From
a
the
Clean
air.
Water and
It
Clean
came
Air
from
Act
the
action, not a
air
climate
to-
change one, though.
Why can't we get the mercury out of Fontana Lake, for example, and examine all of those mercury signatures and then use the Clean Water Act, which is an easier burden of proof?
I mean, you know, again, that's certainly a more particularized case, you know? And so you might be able to do that, assuming you've got the scientific evidence that the court's gonna buy that you can really trace this mercury to somebody in China, you know, that
Or
seems like a
locally,
leap to
or
me.
to-
I don't
I
discount
don't want to
Charles.
go against China because the court will never buy that. What I want to go against is whoever the local
Yeah, well, the mercury,
companies are that are putting the
Right.
mercury up in the air.
Right.
But every time coal is burned, there's a particular signature for that coal from where it was mined
Right.
and the
Why-
way that it was
so
burned.
My question is to you, because this gentleman here in the green shirt, and I think you too also said that you can't have it standing under Clean Water Act because it's coming through the air and into the water. It's not something that they're dumping directly into the water.
I don't think we said that. I don't think
Oh, I
that's
then I
necessarily
misunderstood.
true.
You've got standing and potential claims under, for mercury, for example, under both the Clean
You'd have it
Water
under
Act,
both.
private right of action and.
but the easier burden is under the Clean Water Act, so that's the one you want to focus
Right,
on.
but you're not solving climate change. You're solving the fact that Lake Fontana is polluted with mercury. You know,
But it's a
we're trying to
beginning.
get it a much bigger picture.
But it's a beginning.
Unless you could shut down the source, unless you could shut down the power plant, you know, because of its mercury emissions, or because
Exactly.
of, or shut down a landfill because of its methane emissions and that kind of thing. And I think for the time being, we may do better to focus on both greenhouse gas and other conventional pollutants that we can, you know, we do have a path to stopping all emissions as a way to get where we're trying to go on greenhouse gases.
See, the difference in the case you're talking about is your injury. I mean, if you're suing on behalf of the guy who got sick, that's a very particularized injury.
And that's the beauty of
You know?
it, because that means you've got a person with standing.
Right, he would, yeah, he
And
would,
that's
but
what
he
you're
would have
looking
standing.
for. That's what you're looking for, and the fact that a power plant.
Right, but his standing's not based on climate change. You
No.
see my point?
Basically,
His
Okay,
standing's,
but wait a
his
minute.
standing's based on his
But wait a
physical
minute.
injury.
You start one beat at a time, and if you're able to shut down
I agree
the
with
power plant in Asheville, focusing on mercury instead of CO2 emissions, I mean, it's serendipity that you get to include all of the rest.
Sure.
Well, what this gentleman here is saying, but then what happens is he just gets paid for his injury. You're not shutting down the plant that put the mercury into the air in the first place.
Okay, so you can't obtain an injunctive relief?
Well, you may get a rollback of the mercury emissions going
Right, you
forward.
could maybe get their, yeah, you could maybe affect their permit, of course not gonna shut. You think-
And they don't have to clean up?
Do you
they
think
don't
the
have-
Western District of North Carolina is gonna shut down Progress Energy's plant in Asheville?
Okay, but wait a minute, they don't have to clean up? There's no remediation that
Well, you
could
could
be
get,
ordered?
that's what we're
But
saying.
it
You
still
could-
doesn't stop.
You could get injunctive relief and force them to comply with their permit.
We're not getting to the overarching problem, look at these cases.
Right, I mean, right,
Let's start where we
we're
can.
kind of
Yes,
getting,
I mean,
yeah,
it-
I agree. I mean, you know, any step we can do to, you know, to start it, and again, you know, to start addressing this, but I'm looking at it in a much broader context.
Let's let our presenter finish his presentation, because he's put a lot of work into preparing this presentation. We haven't heard half of it.
I didn't put it.
It's a wild idea, Karen.
No, I mean, again, like I said, I think, you know, thinking about these things and how to do it, but, right, we're talking about little things versus a global problem here. But yeah, but starting with trying to do things locally, and I mean, it's a start, you know, we gotta do something.
And that's what we learned yesterday, local works.
Oh, absolutely.
And you can shut down whole states starting with local. That's what we learned yesterday.
Going back to the preemption, in addition to finding that these folks didn't have standing because they couldn't show causation, the court again found that their entire lawsuit was preempted by the Clean Air Act. And so all of their state law tort claims, and this is really becoming a kind of a trend, and I think it's kind of troubling. You know, when they're finding common law actions, federal and state are preempted by the Clean Air Act, that's frustrating to me.
It's really contrary to legislative history. The Clean Air Act says,
But they both have savings provisions,
right,
you
we're
know,
not
so.
telling
yeah.
the states what to do with their
Exactly.
common law and
Exactly.
statutory thing.
And so, you know, so, right, so now we've got a court holding Clean Air Act preempt state tort law claims. And so, you know, is this the answer to the question of state preemption of state common law claims? Well, there was a decision out of the Western District I'm saying no, the courts are kind of still split on this, luckily. And there was a Western District of Pennsylvania case, I don't remember when it was. Well, yeah, this is the Second Circuit, the Third Circuit opinion. Anyway, the Western District of Pennsylvania in the case, and this actually stopped Gary and I from bringing a case up in Virginia against Goodyear, had found that the Clean Air Act did preempt, like the other cases we've been talking about, found that the Clean Air Act did preempt state common law claims. Luckily, and I just found this, the Third Circuit just ruled on this, and there's the site on it, it's Bellevue Cheswick Generating Station. They overturned the Western District and found that the Clean Air Act does not preempt state law tort claims. And so that's an important decision, and as I said, it had actually stopped Gary and I from bringing a potential case against Goodyear in Virginia, because we were worried about that precedent and didn't want to, you know, do anything to give a court a chance to use it again.
What state was that in, Bellevue?
Pennsylvania. So, and that's, yeah, back to what I said. So, I'll briefly talk about a case that Gary and I did a couple of years ago. Essentially, I'm sure you're all familiar with tar sands, and that's been something that Gary and I have really keyed in on. And we're involved out in Arkansas now with the Pegasus pipeline rupture, which was carrying tar sands. And we like to get involved in anything tar sands related that we can. But this was back in the Southern Alliance for Clean Energy was our client, and they pointed out a provision of law to us that it's called Section 526. It was in the Energy Independence and Security Act of 2007. It's one of Waxman's things, you know, that he got slid in a good environmental provision. But what we did is we brought a case along with we also worked with the Sierra Club out of California on this one, and we were challenging the federal government's, really the Department of Defense's violation of Section 526, because what 526 says is that it prohibits actually federal agencies for entering into contracts for the procurement of alternative or synthetic fuel unless the contract specifies that the life cycle greenhouse gas emissions associated with the production and combustion of the fuel supplied under the contract are less than or equal to such emissions from the equivalent conventional fuel. Okay? So basically trying to limit federal agencies from buying tar sands. That's what it was. That was Waxman's intent. And so, it took a lot of research, a lot of time, a lot of FOIAs, but eventually we got a hold of these contracts between the Defense Logistics Agency, which is kind of the sub-agency of the DoD, which procures all their fuel. And of course we got the contracts. The first thing we noted was, well, the contracts don't have this required specification about life cycle greenhouse gas emissions in it. And then we went further and found that the refineries that the contracts were with were refineries that we could prove processed tar sands. And so we brought an action based under the APA, so we had a procedural injury like mass EPA, and also under NEPA for failing to do an EIS on this. And we filed in the Northern District of California. And we drew a judge named Judge White, who, there's a case called Friends of the Earth v. Watson, and I wish I had the site. And it's a little bit different than what we're talking about factually, but he had essentially found standing in a climate change type case. We drew him, we thought this is great. Of course, what's the government doing? Of course, by now we have the National Association of Oil Producers intervening. We were not liked for bringing this case, to say the least, by the government or by the petroleum industry. So we sued under the APA and NEPA because there wasn't any citizen suit provision under Section 526. So of course the first thing the government did was try to remove it to the Eastern District of Virginia. Unfortunately, Judge White, apparently from what we could understand, just had too busy of a docket, and maybe he probably didn't want to deal with the case. So he removed it, and we get a Reagan appointee, Judge Hilton, who was 80-something, and the first thing we were told by a lawyer who knew him was that he does not believe in climate change. He said, he said. So, but still we went through, filed for summary judgment, affidavits from numerous Sierra Club members, Southern Alliance for Clean Energy members all over the country, alleging harms based on climate change. And then again, having Mike McCracken, who carried the day, and one of the most reputed climate scientists in the country, then piggybacking on all those affidavits, saying yes, these injuries are caused by climate change, including the fact that the government's not complying with Section 526 and they're using tar sands. So the judge killed us on standing. We had an oral argument. He really didn't say much during oral argument, but we kind of knew. And the opinion, which is, it's a Lexis opinion, but it reads largely like interestingly enough, like the government's brief did. It's essentially the government's brief reprinted. But in regards to causation, I'll just read this. He says, for plaintiffs to satisfy the causation requirement, the following logical leaps and attenuated assumptions would have to be made. First, and there's going to be 6 of these. First, if defendants had complied with Section 526, essentially admitting that they hadn't, if we'd have gotten to the merits, we'd easily have won. They would not have been able to purchase fuels which are refined in part from Canadian oil sands. Second, without those purchases, U.S. refineries would not have been able to sell such fuels refined in part from Canadian oil sands to other purchasers, and thus would have reduced their demand for and refining of such crude. Third, if those domestic refiners had reduced their demand for Canadian oil sands, no other purchasers would have purchased the same or comparable amounts. Fourth, based on these assumptions, producers of fuel derived from Canadian oil sands would have and will commensurately reduce the mining and production activities that emit greenhouse gases. Fifth, this reduction would not have been offset by increased emissions anywhere else. Sixth, as a result, fewer overall greenhouse gases would have mixed in the Earth's atmosphere. There's 7. As a result of the emissions reduction, the accumulated atmospheric emissions would trap less heat. 8. There's 8. 8, the resulting reduction in atmospheric heat would result in a reduction in the risk of harm plaintiffs allegedly face to their health, recreation, economic, and aesthetic interest as a result of climate change. So that kind of, really kind of brings home the causation problem. And, we knew we had a problem, but, largely in reliance on Mass DEPA and having the Southern Alliance for Clean Energy and the Sierra Club and all the members that they could bring to bear alleging, very, different injuries all over the country, thought we might be able to get by that.
Hey, Garth, there's still time for a hurricane to hit Virginia.
Right. So in conclusion, courts really have, in the context of climate change litigation, they've limited standing to states that are suing to protect their interests and their citizens. Parents patriae. And courts, while there's still, again, the scholars argue about it, there's clearly a relaxed standing analysis when you read the cases. And so for private plaintiffs, the question is, how do you prove causation? And then we've also got the preemption question now, which while Mass DEPA is such a great decision, the courts have taken that and ran with it. Who knows if this was intended or not? But to say that that common law claims are preempted by what the court said the Clean Air Act and EPA was authorized to do in Mass DEPA. And so that's all I have. And if we want to get back into a discussion, I'm certainly more than happy to, because if anybody has thoughts on this, I don't claim to be an expert on it. I'd love to hear what anybody has to say.
We've tried to go about it a slightly different way. Most of our practice is representing demonstrators, and lately that's folks trying to block coal shipments going to China. So we have tried to raise it as a necessity issue in criminal cases. We haven't gotten there yet, but we've gotten judges discussing it. We've gotten potential receptiveness. So I'm thinking if we can actually get this into the courts that way, where there's no standing issue, we might be able to start making it enough of a legal discussion that we may get to the other end of this. The only thing we've been able to think of. And clearly imminence is not a problem.
Right.
And we've got an agreement that imminence is not a problem. That causation isn't. We just haven't had a judge at the trial court level with the guts to let us bring it yet.
Our judge in the Eastern District of Virginia found we hadn't shown injury, in fact, causation, or traceability. Yeah, he didn't leave much doubt. He didn't want us to appeal on it. So, Karen.
So where is the Waxman provision? Which statute is that?
It's called the Energy Independence and Security Act. I'm trying to
Is it a rider on another?
No, it's a section within it.
Within the Clean Air?
Within the Energy Independence and Security Act.
Okay. So it
and I'm
sounds
sorry, I don't have the statute.
No, that's all right.
On that. Yeah, if you look it up though, or if you just Google Section 526 climate change or tar sands, you'll find it.
So it sounds like we need some enlightened attorneys general to bring suit under that provision.
And we actually it's been several years, I can't remember last week, but we did some outreach after the case trying to see if we could get some states involved.
Yeah.
We just never, couldn't get any firm commitments from anybody.
New York and California, that's all I have to say.
Right, yeah, right, exactly.
Yeah.
And that they should use it.
Yeah.
But again, if it's going to get removed to the Eastern District of Virginia, draw good old Judge Hilton, right? If they'd want to get involved, right? They'd want to do that. So, yes, sir.
Is there any provision in NAFTA that will allow the prevention of Canadian tar sand derived oil from coming into this country?
I certainly don't think so. I mean, with the Keystone debate going on right now, if there was something in NAFTA that could go ahead and just kill that.
No, NAFTA encourages.
Yeah, I think NAFTA would actually probably be more of an encouragement than a prohibition on that. And I mean, that's, when we're talking about this, I mean, obviously Keystone and whether it's President Obama or whatever happens, that's going to be a really huge issue coming up. I mean, I don't know if many of you have taken time, and I should have put a few pictures on here of what this Athabasca region of Alberta, where they mine all the tar sands. I mean, it is despicable. It really is. What they're doing to the environment up there.
Actually, if Keystone is vetoed, why, there's quite likely to be a challenge to that in front of the World Trade Organization, because generally these trade agreements say that enforcement of domestic environmental laws are obstructions in international trade. So both the protection of labor and the protection of your own environment, or the world's environment, is objectionable under international trade law.
Yeah, I think I heard of a case recently that a U.S. energy company is suing a Canadian province that banned fracking.
Yes.
Oh, really?
Yeah.
And
Right.
I mean, to me, that's just deplorable, that now corporations are more powerful than a township itself to determine what they want to do.
Oh, absolutely, absolutely. And there's also, there's tar sands up in North Dakota. And if y'all know if y'all heard about the Lot McGantique, the little town up in Quebec where the train ran down the hill and blew up the whole town, that was tar sands coming from North Dakota.
Yes.
What about the tar sands in Kentucky?
Really?
Do you know anything about it?
I didn't know if there is any.
I mean, that's a possibility in
Yeah.
the future. I think they said that it's not worth mining,
Right.
but I don't necessarily
And, yeah,
believe
I've even
that.
seen things saying it's not worth mining in Canada. But
Right.
It's not stopping them.
Exactly,
How
so,
they not paying the cost?
Right, and nobody pays any attention to North Dakota, and that, I mean, in fact, speaking of pipelines, I don't know if y'all saw this, some farmer last week was out harvesting his hay, I think it was in North Dakota,
North
not in
Dakota,
South Dakota, and he found like
20,000 barrels.
20,000 barrels of oil that had spilled from a pipeline, just like the Pegasus pipeline, but I forget which oil, it might have been Tesoro. They didn't even know about it.
yeah.
They didn't even know about it, and I guess it was confined to this one landowner's land, so there might not be a whole lot of litigation coming out of it, but they didn't even know about it. There was a huge hole in the pipeline. It was so this guy's out harvesting his hay or his wheat or whatever, and he started smelling something, feeling kind of funny, and there was thousands and thousands of barrels of oil on his property, which I'm sure were heavy crude tar sands or something.
Yeah. One of the things that people should think about in those situations is if you could require daily inspections of pipelines from aerial surveillance or on the ground, the way they do railroads for safety in many cases, you could actually increase the cost of pipeline transportation of these petroleum products enormously and discourage this huge expansion of pipeline.
Well, that's what we're finding out in Arkansas is that ExxonMobil, this pipeline was this pre-1970, or the welds on it, this pre-1970 electronic resistance welds, that it's codified that they failed. And ExxonMobil doesn't care. They reversed the flow on this line so they could start pumping tar sands down and increase the amounts and all that. And of course they've come up with plenty of excuses now showing they're not at fault. They did everything they could. But that's ongoing litigation. We'll see what happens. Yeah.
But these conversions and reversals, like the Texas Abandonment Project and the Bluegrass Pipeline, is there any way to fight those at all? As far as, because I've just been told it's not worth it legally.
Well, I mean,
unless it's a new construction.
What's the question?
Yeah. So are you these new projects?
Well, most of them are not. They're they're doing an abandonment of a natural gas line, and then after it's officially abandoned, they're going to convert it
Yeah, I
to
don't
do
know.
tar sands.
There's the pipeline, PIMSA is what it's called, Pipeline Health Safety.
Hazardous
Yeah,
material
yeah.
safety.
But PIMSA is worthless.
Right.
They're worse than whatever the agency was that was in charge of drilling in the Gulf.
Uh-huh.
I mean, even in, I think the head of PIMSA recently came out and basically said, we don't have control over anything. He admitted it. So, yeah, I mean, challenges, maybe NEPA, I don't know, or state NEPAs, have they done an EIS to?
I don't think they're
potential-
required to when they're just doing a change, unless it's new construction, I don't think they have to do an EIS.
Yeah, I don't know.
Yeah.
Sure.
We came through Williston, North Dakota on the train, which is where the stuff is based, and it looks very different from any other refining process we've ever seen. Aside from the fact that half the train gets off and gets on in Williston now. The amount of places where they're burning where they're heating the oil to make it usable is just really striking. The amount of smoke is really striking. The air is far worse. There's got to be a ton of clean air.
And clean water. And you know what they have to do, because the heavy crudes is so thick, it won't go through, it's like a slurry. It won't go through a pipeline, so they just dump a bunch of benzene in there to get it to flow down. And so that's why, like out in Mayflower, we're finding, high levels of benzene in places. Because it's called diluted bitumen is what they call it, dilbit, and to dilute it, to get it to flow through the pipeline, you got to use something, whether benzene or natural gas or something like that, to get it down to where it'll actually flow through a pipeline. The tar sands, I think, are largely overlooked, and it's terrible what they're doing up there in Alberta, and of course it's having a very dramatic. I mean, look at Keystone. I mean, look at all the money behind it. Whether it's just the Cook or Cotton Brothers or whoever they are. And everybody else. But yeah, somebody was talking about if Keystone, even if Obama, puts the kibosh on it, I mean, that's...
Well, they have all these other pipelines ready to go.
There'll be so much fight over it. I mean,
How much is Keystone just a red herring to distract us from all these other pipelines?
I think it largely is. I think it largely is, right. I mean, and don't need to look any further, like I said, than our work in Arkansas. That's a terrible pipeline that shouldn't even still be being used. And, everybody's so focused on Keystone, they don't look at that, or the one in North Dakota, or the one out in Yellowstone a couple years ago.
The Bluegrass Pipeline's going to go straight through West Tennessee.
Mm-hmm.
So, I mean...
And at some point though, I guess we'll have to decide, I mean, it's going to happen, what's the safest way to do it? And then we see the train go down into Lock McGantique and blow up an entire city.
Oh yeah.
So is rail really safer?
No.
I mean, so you have to be careful. You argue on one hand, well, pipelines aren't safe, and neither are trains.
But the
We
issue...
gotta focus on the tar sands itself then. We're getting the unit trains like crazy now. No regulation. They push them through the refineries because it's existing refineries, so they didn't have to go through NEPA.
Right.
So it's,
Well, that's what all the refineries are, the government told us in our case was, well, sure, these refineries use tar sands, but it's blended with everything else before it's refined. And so, the question then becomes, is it really, was it even a non-conventional fuel under Section 526? Because, the government's like, we're just buying whatever's commercially available, blah, blah, blah. They know what they're buying.
Oh, yeah.
And so...
So do you not need the benzene or the natural gas in there if you're putting it in trains?
Good question.
I think
I
you still
don't know
do.
I think you do. I still wonder
It's
why
loaded
those,
and unloaded.
I'm still wondering why did those train cars explode?
Yeah.
When they went, if it was just unrefined crude oil in there,
Yeah.
it's not gonna blow up like that, I don't think. I don't know, people might disagree with me.
No, they've got to be using
There had to be some
something
sort of flammable agent in there, so I think it would almost say that they're still adding it, because when they want to get it off the tanker,
Yeah.
It's gotta flow.
It might not come out if you don't somehow dilute it,
And most of the tank cars they're using were never tested or certified for transport of that kind of a mixture.
Right.
Really?
Oh, yeah, they're just old school,
They're just leftover tank cars.
No tank.
I think you just came
Not
up
the
with
very
the
designs that have been made for this stuff.
Yeah, but I encourage everybody, just kind of do a Google search for dilbit and start looking at this, all, tar sands to the extent people aren't. I know everybody here is probably turned on to it, but most folks aren't, and it's awful. And of course, the extraction of it and the environmental damage that does, and then, the higher greenhouse gas emissions it burns when it's combusted. It's bad stuff. Anybody else? I guess we're about out of time. So it's-
Evaluation, give them an A.
Thanks all.